In this final set of lessons for jurisprudence, what we're going to do is move away from looking at legal positivism as a theory of law and start to talk about sociological theories of law. Now, these are less specific theories like natural law versus jurisprudence, for example, but they're more theories that are connected by the idea that they are more sociological in nature. And so, as a result of which, we're going to focus on three major sociological thinkers when it comes to legal theories. We're going to talk about Karl Marx and Marxist theories of law. We'll talk about Emil Durkheim and how he interpreted theories of law. And then we'll finish by thinking about Max Weber, who actually was a lawyer, and think about how he determines and develops theories of law as well. This video, as you can see here, is going to talk specifically about the first of these. We're talking about law and Marxism. We're going to talk about how Marxism approaches theories of law and develops a theory of law which is really interesting in terms of its philosophy. So we're talking about the works of Marx as well as other sociological Marxist thinkers, so individuals who will also sort of fit into this sort of socialist, communist school of thought and generally Marxist schools of thought, and how they approach law, the nature of law, what law is used for, and the ultimate final purpose of law, assuming that some kind of theory of socialist revolution were to take place. We will also spend a very brief, when I say very brief, I mean very brief minute thinking about Karl Marx theories of society, philosophy, political theory, just so you have a very basic understanding of what Marx said generally, so that we can then take that and apply it to the law itself. So, one of the things that's interesting is that comprehensive theories of law is not something that really we can find in the writings of Karl Marx. He wrote a lot about economic theory, so in Das Kapital, in other works like Critique of the Gotha Program, the Paris Manuscripts. He focused on things like political theory or historical theory, or ideological theory, the German ideology being a very important work, the Grundrisse being another important writing by Karl Marx. All of these things he focused a lot on. He never wrote a comprehensive study of law. And so law, as we understand it and how Marx understands it, is sort of developed and is a theory that is developed out of and picked from the writings of economics or politics or philosophy that he has developed. So Marx and Engels working with Karl Marx on a lot of the writings that he had done, placed greater emphasis not on legal issues and the concept of law, but more on economic relations within society. Noting that the economic relations within society, what Marx terms the material conditions of people within society, are more important than the concept of a legal state. Law simply forms what he describes as part of a, quote, superstructure of society, and that this superstructure of society is composed of a multitude of different things, a myriad of other cultural and political phenomena, and that law only forms a small part of this broader superstructure of society. And so it's with this view and with Marx's understanding of law as not being as particularly important for understanding how society operates than that of economic relations, it means that we can understand why he doesn't provide much of a comprehensive account of the law. So let's think about what Marx's account of society is. Well, Marx understands society as something of an historical one. What does this actually mean? Well, he believed that social evolution can be explained in terms of historical forces. Now, what Marx does is take from the writings of German philosopher Hegel and develop a theory of dialectics. Now, dialectics, a dialectical relationship, is just one that is one of an opposite, diametrically opposed forces that are in contrast to each other. So the north and south pole of a magnet, for example, could be seen, if we were to take that analogy to one of a social theory or political theory, as a dialectical relationship. They are opposing forces that push against each other. That's what Hegel believed when he argued and wrote about dialectics. Marx and Engels takes this theory and proposes an idea known as dialectical materialism. And what dialectical materialism means, we got the understanding of what dialectic is, but when we talk about materialism and what materialistic he's talking about, he's referring to the concept of the means of production and the idea that the means of production are materially determined. The means of production being the means of economic production. Okay. It is dialectical, since that society exists as an inevitable conflict between mainly two opposing forces. And what this societal dialectic is class dynamics between those who own the means of production and those who simply work and have their means of production essentially taken as part of their labor. And we'll get to this in a second. So simply put, when we think about the means of production, there are those who work and there are those who own the means of production. And it makes more sense to understand this from the perspective of like a classical economic system, like a factory, for example. And what Marx argues here is that the value that is created in products and economic produce comes out of the labor that is put into it. This is known as the labor theory of value. You mix labor with some raw materials, like the raw means of production, and you get the value of a product, like a phone or like a TV or whatever. It is not just the parts on their own that creates the value of a television or a phone. It is the labor that goes into that is where the value comes from as well. And so essentially what Marx argues is that those who own the means of production, own the factories, for example, they exploit the labor of those who work the factories. And that there is a inherent moral wrong and an injustice in what Marx describes as alienating one person from their labor. You feel alienated from your labor. A lot of writings on the Paris manuscripts come out of this idea of alienation of labor. And so the result of this is Marx proposes something of a revolutionary change where those who work and who have their means of production exploited will take the means of production from those who own the means of production and create a socialist state, a socialist society. There's no such thing. I mean, in terms of statism, Marx wasn't a statist, so the idea of a socialist state doesn't necessarily make sense in relation to Marx's writings. So let's think about how we apply this to law. Because Marx suggested that law only forms part of this superstructure of society, he still argues that it makes sense to suggest that law plays an important ideological role. Now, what Marx argues here is that within society, the working class develop what they describe as a consciousness of their situation. There is a consciousness of the plight of the working class, those who have their labor exploited, and those who are subject to alienation of labor. These are the real injustices that Marx describes as being part of the working class mindset. This class consciousness develops as a result of the material conditions that they are in. It is the material conditions of being somebody who is forced to sell their labor for profit in order to be able to survive and to live. And it is those who, the bourgeois within society, those who are the owners of the means of production, who take their labor and make profit and exploit from that of the working classes. We develop our knowledge from social experiences, and then as a result, this class consciousness of the material conditions that they're in is developed out of this social experience. And so law fits into this story as simply a maintenance of the, quote, natural order of things. It suggests that it represents the interests of the dominant class, of the bourgeois class, who are able to exploit and keep down those who are working for and selling essentially their labor for profit. It maintains the status quo. It maintains the status of capitalism as being that of a situation and an understanding of society which is inherently unjust and immoral. And so as a result of this, according to Marx and Engels, what law is seen as is part of the superstructure of society. It is not seen as the most important element of society because that is, of course, the economic relations between class. But law is therefore a vehicle of class oppression and a maintenance of this status quo. And so where where class is eliminated in a society, i.e. a transition into socialism, their need for law, because law is simply a vehicle for class oppression and the maintenance of a status quo, the need for law becomes more limited. They argued, Marx and Engels argued, that once there is a proletarian revolution, i.e. the people who are stuck in the material conditions of having their labor exploited, take back society, claim the means of production, they claim and they take ownership of the means of production, they establish what is known as a dictatorship of the proletariat, where essentially the class that is exploited essentially takes control of society. And so post this situation, you end up in a situation where law, or the state even, does not need to exist. So a lot of people make a number of different mistakes when it comes to what Marx means by socialism and communism. Marx doesn't really make a delineation between socialism and communism. The only time there is a delineation between socialism and communism is this idea that Marx is critiquing the sort of French, the French Enlightenment ideological socialism that existed and sort of developed before Marx's writings. So given that fact, what Marx suggests is that when there is a dictatorship of a proletariat, when there is a proletarian revolution, the dictatorship of the proletariat is a period of transition into socialism. There will be a transitionary period whereby the state and society is organized in such a way as to develop into a truly socialist or communist state. And at that point, the state itself would cease to exist, or would cease to need to exist. So too would law. Now, when we say dictatorship of the proletariat, Marx, that's just the translation. Marx doesn't mean dictatorship in the way that we understand dictatorship today, where we have a brutal, ruthless dictator who runs and controls all of society. Dictatorship in Marx's writings simply just means control, or a monopoly of the proletariat, if you will, full control. Let's think about some of the issues that we have with Marxian legal theory. The most major critique, when we talk about not just Marx's theory more generally, but Marxian legal theory, is the analysis of law is described as quite oversimplistic. The materialist account of the law will run into a number of problems when we can provide examples of governments passing legislative acts which actually improve the conditions of the working class. How can we suggest, therefore, that the concept of law, the institution of the law itself, is simply a tool, a vehicle for the oppression of the working class, when legislation and court decisions and the development of law have been very beneficial to the working class in a number of different ways, especially when it comes to things like employment conditions, when it comes to things like familial relationships and the breakdown of marriages, which can happen in situations where you have working class situations. What about situations, for example, where you have those who are threats of eviction, and there are housing rules and housing requirements that essentially require the landowners to provide property of a certain standard? All of these are examples of laws that are, in a way, developed to help that of the working class. Now, it almost contradicts suggestions made by Marx. Obviously, you can critique that and suggest that these are merely small improvements to the symptoms of society. They don't really get to the heart of the true nature of the plight of the working class. And so as a result of which, you can come up with all of these examples, and they can be seen as examples, but the law itself on a whole is still one that is geared towards that of those who own the means of production rather than those who have their labour exploited. That is a valid critique of the critique, if you will. Equally, though, some will take issue with the suggestion that there would be no need for law in a communist society. It seems to be the case that a considerable body of law is required to serve a number of functions even within the classless society. What about crime? Does crime still exist in a classless communist society? Now, depending on which kind of Marxist you're thinking about, they may say no to that answer, but generally human nature seems to suggest that a communist society would still probably have crime. What about economic regulation? These can all also suggest that there is the need for law in a classless society. And even the experiments with communism that we even saw in the 20th century had considerable legal systems in place. So the Soviet Union, Mao's China to a lesser extent, places like Vietnam, places like Cuba had laws and regulations still. They were slightly different, but these are examples of communist societies, in inverted commas, that still required the existence of law. So this is another major issue that you can really take with this idea of a Marxian legal theory. And it suggests that, on the whole, while Marxist legal theory can still be particularly useful in explaining certain elements of the law, it may be may need a bit more in order to essentially be a bit more sophisticated in developing a more substantive theory of legal regulation. Hello everybody and welcome back to Jurisprudence for the Law Academy. As a quick introduction, if you want to support this project and get access to additional content and materials, please consider becoming a channel member. This is allowing us to essentially keep producing the content that we love to do and to teach law in the way that we love to do it, and to make sure that all of this content is free and available for everybody. Alternatively, if you want to make a one-off donation, please consider the super thanks option under the video. This video specifically is going to be talking about some more sociological theories of law. Specifically, we're going to be talking about the concept of law and the ideas of law as encapsulated and as contextualized by the sociologist Emile Durkheim. So, the last lesson, we talked about the way in which Karl Marx analysed law within society, talking about Marxist and socialist theories of law. Again, we didn't do that much detail in terms of the real in-depth analysis that Karl Marx attributes to law, especially given the fact that Marxism is more than just Karl Marx and Friedrich Engels. It is people like Rosa Luxemburg, and then we start to get into some of the more legal-oriented scholarship on Marxist theories of law, Marxist theories of international law, all of which we might do a series of videos on in the future, looking specifically at Marxist theories of law, which I believe would be quite interesting. But fundamentally, we took an overview to Karl Marx's conceptualization of law within society. This lesson is going to look at another sociological theory of law, this being the sociological theory developed by sociologist and key thinker Emile Durkheim. So, as a basic introduction, Durkheim was a sociologist who supported the concept of functionalism, a functionalist within sociology. Now, for those of you who have studied sociology, you'll be amply familiar with Emile Durkheim. Some of you may have done sociology at A level, for example, and now have come up to do a law degree, an LLB at university. So some of these things you might be already familiar with. But fundamentally, Durkheim was a sociologist who supported this idea of functionalism. Functionalism is something known as a structuralist sociological theory, which means that what they do as a structuralist is to examine the nature of structures within society and the ways in which institutions and structures essentially hold societies together and hold the functions of societies together as well. And so really from this idea, and from this idea of structuralism and this idea of functionalism as a conception of structuralist sociological theory, you can really start to embed Emile Durkheim's understanding of law in these same ideas. And so the result of which is that Emile Durkheim argues that law plays a crucial role in this idea of social cohesion. Again, being something of a structuralist theory, examining the nature of structures within society and examining what holds societies together. Essentially, one of the answers to this question, what holds societies together, according to Emile Durkheim, is a theory of law, and law itself, a crucial role in the maintenance of social cohesion. What Emile Durkheim suggests is that as society, develops from religion to secularism, as it shifts away from religious conceptions to secular conceptions, law becomes less of a tool for punishment and more of a tool for remedy and compensation. Now, Fundamentally, one of the things that's quite interesting is that when we examine sociological theories like religion, law plays a key role even in that part of society as well. When religion was the key and dominant construction of society, when you had Catholicism, for example, in the medieval period of English society and European society, canon law and the law of the church was something that essentially regulated society in the similar way that religion regulated other parts of society. And so this shift away from religion to secularism shifted the role that law played as something of a religious conceptions of law, to more secular conceptions of law. Law becomes less of a tool for punishment and more of a tool for remedy and compensation. Because Durkheim was what is known as a consensus structuralist, he argues that law and punishment play a significant role in the expression of moral attitudes, which is something of, if we were to attach theories of the criminal law, is something of a legal moralist conception. For those of you who have gone through our lessons on the criminal law, we spent a little bit of time talking about theories of criminalization, and one such theory of criminalization is this idea of legal moralism. Fundamentally, the study of criminalization, at its heart, at least one of the key questions and the key understandings that you have to really think about when we talk about criminalization is, how do we justify criminalization, given the fact that the criminal law fundamentally restricts somebody's ability to do a thing, and if they do that thing regardless, you are then restricting their freedom in some way, either through prison sentences or even through fines and things like that. Given all of those things, given the restrictive nature of the criminal law, the decision to criminalize some kind of conduct, the decision to make something criminal, is something that requires a particularly heavy justification. One of those justifications is this idea that criminalization can be justified on the basis of promoting moral attitudes and promoting morality. Fundamentally, a thing is criminal because it is immoral. And so as a result of that is we can criminalize it on the basis that it is violating some fundamental maxim of morality. Okay, Durkheim, being something of a consensus structuralist, would somewhat support this position, at least when we talk about his conception of the criminal law. Of course, his sociological theory of law is a bit more all-encompassing, because he suggests here that law is an expression of moral attitudes, and so as a result of which, criminalization can be justified on the basis of expressing moral attitudes. Durkheim distinguishes in his sociological theory of law between what he calls a mechanical solidarity and an organic solidarity. And really what this means is mechanical solidarity or mechanical society is something that exists within more simple societies where there is a uniformity of values. And then societies of this nature are considered to be more collectivist. There is less individualism. And this is again something that is expressive of simple societies, of earlier societies, of smaller societies, where there is less room for disparity in ideas and disparity in beliefs and disparity in moral consensus. Instead, there is collectivity in these ideas. There is less individualism in these ideas. The more advanced and complex societies have a higher tendency of individualism. They have a higher tendency of disparity in terms of various different beliefs and moral attitudes. And so Durkheim suggests that our understanding of solidarity is reflective in our nature of the law and how we are to understand the law. In relation to specific elements of the law and specific elements of the legal system, according to Durkheim, the existence of crime, for example, the concept of crime not necessarily in the context of the criminal law, but the context of crime as a thing that happens in sociology, a sociological understanding of crime, is just a normal part of society, and it is also something that is integral in society. Fundamentally speaking, every single society has crime. How we are to define crime is really up to criminologists and up to philosophers of the criminal law, but fundamentally, assuming that we can come to some kind of consensus as to what crime fundamentally is, according to Durkheim, that thing that we have defined as crime always happens, and it is part of a normal functioning part of society. And so because crime is so closely connected to social values that it is expressed in a collective moral conscience. Again, remember, consensus structuralism, something that Durkheim suggests is something to do with moral attitudes and an expression of moral attitudes. When something contradicts the moral conscience, it becomes a criminal offence. So very much conceptualizing himself as a moralist in this regard, okay, suggesting that really what happens is that the moral conscience, the contradiction of the moral conscience, the violation of the moral conscience comes first, and the criminal offence comes second. And so fundamentally, we have a sort of collective understanding of what morality ought to be, a collective moral conscience, okay? There may be disparity and distinction on the towards the edges of these ideas, so fundamentally, we can all essentially conclude in a society and agree on certain moral maxims and moral values. So, for example, we can all probably agree that murder is wrong. This is a core component that most people agree with. The reasons why that is the case is, of course, something that we often differ depending on what kind of normative ethical theory everybody ascribes to, but all of them seem to come to the conclusion that murder is wrong. So if you're a utilitarian, or an act utilitarian, or a rule utilitarian, you will come to the conclusion that murder is wrong. If you're a deontologist, a Kantian, you would say the same. If you were a virtue ethicist, a situation ethicist, etc., 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 you all come to the conclusion that murder is wrong. And so when somebody contradicts that basic moral virtue, then it becomes a criminal offence, i.e. something like murder. And when I say that we can all agree on some of the core components, things that are blatantly obvious, but then we can come to disagreements, and there are disparities when we have a look at some of the more complex, more edge cases. So things like abortion, euthanasia, certain elements of sexual ethics that obviously intersect with religious beliefs, all of which are far more debated, and then the extent to which they can be considered to be a criminal is a far more philosophically interesting conversation. But this is what makes an act a criminal act, a contradiction of moral conscience. And then in this similar vein, what Durkheim suggests is, just like with crime, the idea of punishment is an essential concept within society. Not only is it an essential concept in society, but by extension of the fact that punishment is something that comes after somebody's commission of a crime, it is an essential concept of the crime itself. When an act is considered a crime, it upsets the collective moral conscience. And so the state steps in to make that moral conscience right, to make right the wrong that had been committed by applying a punishment to said crime. And so in this sense, you can come to some kind of conclusions as to how Emile Durkheim understands the purpose of punishment. It is seen to be a thing that comes in to try and rebalance the disparity that exists as a result of the upsetting of the collective conscience. And so the result here is that we can understand punishment theory through Durkheim's perspective as well. Welcome back, everybody, to these lessons on jurisprudence. As a quick introduction, if you want to support this project and get access to additional content and materials, please consider becoming a channel member. This will also ensure that we can keep producing content and doing what we love, which is the creation of legal content for free. And alternatively, if you want to just make a one-off donation, please consider using the super thanks option under the video below. Now, this video specifically is going to be the last video looking at the sociological theories of law. It's going to be the last video looking at this basic introduction to jurisprudence. We might do some more advanced concepts in jurisprudence in the future, because there are lots of other elements of the law that we haven't yet really considered in much detail. This has just been a basic overview of the key major themes. We've been talking about natural law, we've talked about legal positivism, and we've talked about sociological theories of law, the sort of three main pillars of jurisprudential thought. Like I said, we can talk in detail about critical theory and critical legal theory. We could talk about feminist interpretations of law. We could talk about some of the more radical theories of law, anarchist theories of law, for example, and all these different things. We can even go into the ideas that we've looked at at the moment in more detail. And we could also talk about the philosophy of law from the perspective of the specific subdisciplines. So the philosophy of criminal law, the philosophy of tort, for example, the idea and theory of contracts, all of which we will likely do in the future, potentially. But for now, this is just going to round off the series of videos that we've talked about in relation to jurisprudence in its general form. And we're going to finish by talking about the works of sociologist Max Weber. and talk about what Max Weber believed about the law as part of his broader sociological theories. Okay, so this is the final lesson looking at sociological theories, talking about the legal theories developed by Max Weber. We've spoken already about Marx and Marxism and Marxist theories of law, and we also talked about the theories of law as expressed by the sociologist Emile Durkheim, the sort of consensus structuralist theories of Emile Durkheim as well. So we're just going to round this off by talking about Max Weber. As a basic introduction, Max Weber was actually somebody who trained as a lawyer. So one of the things that is important to note here is that his background as a legal professional, as a legal individual who was a trained lawyer, of course, could and does, in fact, play a very key and very central role in his broader theories of sociology and his broader theories of how law plays a role within sociology, his sociological theories of law. What Weber does is highlight the importance of understanding society through the lens of different systems. He takes this sort of systems-based approach, and so what he does in doing this and in taking this systems-based approach is distinguish what he calls a formal system versus the substantive systems, the distinguishing features of those two systems in this regard. And what Weber does and what Weber argues is that the difference in these systems relates to the rules and procedures that are required for internal decision-making. Weber adds to this concept that materials are applied in the system either irrationally or rationally. And what Weber argues is when we start to think about these systems and the rational application of things within these systems, the rational law, the way in which law intersects in this broader conversation, is one of the main preconditions for the existence of capitalism. And so he justifies this on the basis that what the rational law does is provide necessity, certainty, and predictability. These are all very important concepts within the broader conversation about market capitalism. And so he makes this link between law and capitalism, and the rational law and the development and the existence, the preconditions of the existence of capitalism, essentially arguing that this idea of law being something of a provision of certainty and predictability, whether or not somebody is guilty of a crime, can be predictably determined on the basis of evidence that is presented, and so a law, for example, is not unpredictable. Okay, the application of the law is very much a predictable system that is applied. So these are all, like he said, elements, important elements that are related to the idea of and aspects of market capitalism. And so what Weber says is that the formal rationalization of law is the result of capitalism interested in the formal law and the legal procedure. And this really does ground his understanding of the law as being a broader conception of capitalism, the result of capitalism. Capitalism exists and began to develop out of the sort of feudalism and mercantile projects that existed in the sort of 1700s. We then start to see the development of capitalism in and around the development of the Industrial Revolution. And at this same time, according to Max Weber, we see the formal rationalization of law as the result of this development of capitalism. And this really gets to the question of the ways in which and the reasons and justifications for obeying the law. What Weber states is that there exists three kinds of, quote, legal domination, a system by which people are obliged to obey the law. You have this idea of traditional domination, in which legitimacy is justified on the basis that on the sanctity of old rules and powers. You then have what is known as charismatic domination, which is justified on the basis of devotion to the exceptional sanctity, heroism, or explanatory character of an individual person. And then finally, you have this idea of the legal rationale, the justification that rests on, quote, the beliefs in the legality of enacted rules and the right of those elevated to authority under such rules to issue commands. So all of these ideas sort of give us the kinds of legal domination, the ways in which law is able to be obeyed in this regard. Of the three, of course, as you would understand, what Max Weber does is emphasize the importance of the latter, the idea of legal rationalism, the idea of the rationalization of law as a method of obeying the law. When society is dominated by this idea of a charismatic leader, the second of these conceptions, legal thought is formally and substantially irrational. It doesn't operate in a rational setting.